Okay, thanks a lot, Dick. Good morning, everyone. I'm Kevin Lyons, Deputy City Engineer. And I did hear a word, for those of you that are listening online, there's no way to get the word. People really need to know this, but I understand the online connection is maxed out, so people really are trying to get on and are unable to. So those of you online, if you're getting emails from other people, you might want to just pass the word that currently maxed out on that. We really apologize for that. On this question of representative study period, it does segue nicely from the talk we just had from Dick. A lot of the issues, a lot of this exchange that we have is really helpful for me as we go into this discussion of representative study period because it's a very specific item. But everything overlaps quite a bit, and when we talk about it, we have to talk about the state engineer's role. That's part of the question. So to focus on what I want to talk about is the representative study period in a change case. That may play out in water corridor, or it may play out in the substitute water supply plan. And just by way of introduction, I'm going to say that I'll really explore some of the different aspects of this. There are legal, engineering, or technical aspects. There's administrative, policy aspects. And we want to explore that. But when it comes down to it, each case we're going into is going to have different facts, and we'll have to address those one by one based on the specific facts. But having said that, I think we can still have a general discussion about a strategic approach to dealing with this issue. So as you know, I think looking at the crowd and all familiar faces, you know that the state division engineers have been really engaged on this question of representative study period over the years, and we are right now in some cases. And to focus our discussion, this is generally about irrigation water rights. We're talking about a period of record of use for irrigation water rights. And there are numerous scenarios when it comes to that. And the scenario I really want to focus on is that case where you have a history of use of the water right, and it stops at a certain point in time up until the date of the application for a change case. So the chronology is that we've got an appropriation date and commencement of use of the water right, and it's used for a long period, and then that use stops for a particular reason, that the land was taken out of production, it was subdivided, the water right was sold to some municipalities, something along those lines that cause it to stop at this point and not be used further. So when we have that scenario before us, there's several, I feel like I'm just drifting right on the cusp of being proven off, so hopefully that's all right what I have to make there. When we have that scenario, there's several considerations before us, and of course one is no injury. That's an easy one to say, it's a difficult one to deal with, but we know that the water courts told us you cannot cause injury when you change the water right. And I guess going along with that is no enlargement of use when you change the water. What about the question of including non-decreed use? That's been before us in the last couple of years. And there's also the question of, well, can you include only the best years or only the worst years? That's a consideration. We've had two recent cases, the Sedalia case and the Busk, Idaho case. And by the way, before he gets away from me, Paul is up here. He looks great, but he's not up here just to look great. As we get into the discussion on some of the case law and some of the questions on that, we certainly need Paul to help us with that, or we can't say that. Lastly, I'm going to say that Senate 183 in the last session did a lot to give us something to consider when we have this question of what years need to be included in that representative study period. So in the end, we're really talking about the question of how to fairly represent the value of that water right in a change case, and at the same time make sure that other water rights are not being removed in that process. So let's start out with what is the state engineer really doing and why? And part of this, again, is we're helped a little bit by the discussion Dick just had, because I think that is still an open question. What's the appropriate level for the state engineer to participate in this? But certainly, that determination of a representative study period is integral to historic consumptive use analysis. if you're going to do the numbers, you have to either agree with what someone has proposed or propose something different. So even though the issue is not a technical one itself, it's part of that technical analysis that needs to be done. So that causes us to ask the next question. Why is the state engineer involved in that technical discussion in the first place? And we know for such a large pipeline, it's because the statute directs the state engineer and is set to be involved in that. But what about water court cases? Well, and again, I'm going over some of the ground that covered before, but we do know in the past that the state engineer has been involved generally as an opposer on this question. So you have that, but listening to Dick's discussion, maybe that's not appropriate that the state engineer play that role in that way as an opposer, but instead could be possibly a technical advisor to the court and not in that adversarial context, but as that objective technical advisor to the court. And then, as I said, we have the role in the SWSP request. So we could ask, does the state engineer need to make decisions of representative study period, or just decide not to engage on that, other than to determinations of SWSP requests? And I think you're seeing us right now. We're in discussion. We're in transition on that, and this type of discussion we have with you folks today really helps us with that discussion. So in deciding on an approach and decision on a representative study period, I feel like we have 4 major areas that we consider. And the first one is just going to be considerations given us by the Supreme Court on a matter and not causing injury through an expansion of use in a change case. So that's one. The second one is the allowances we got from Senate Bill 183 during the last session. The third one is just the application of the concept that junior water users are entitled to stream conditions that they found at the time of their appropriation. So that's a good concept. I believe it's difficult to put it in practice. That's the third one. The fourth one, again, I'm going back to Dick's discussion. It's not a coincidence that he led off with that. What is the state engineer's role in this policy type discussion on representative study period? Because if it does break away from technical discussion, it becomes policy oriented. So first off, I'm going to start with that first one. Guidance from the Supreme Court on the question of a change of water right, and we start out with that statement from the court that it cannot cause injury. And that would be a great place to stop, because I think we can all agree to that a change of water right should not cause injury, but it's just not that easy, because we do have to continue on and understand what injury means. So the next step would be to say, take the guidance from the Supreme Court and say, to ensure that there's no injury, you cannot enlarge the use of the water right. And that would be one standard for ensuring no injury, not enlarging the use of the water right. Problem with that is enlarge implies a relative analysis or comparison. So enlarge compared to what? Well, that's another tough question. What is the standard against which it would be an enlargement? So I think the next answer we get from the court is that it cannot be enlarged beyond the average historical consumptive use over a representative study period. So now we've really brought ourselves to that point where we need to discuss the representative study period, because that's the direction we have from the court. In changing a water right, as the wise people of DWR have advised me, you do run that risk of requalification. So when you go in to take your water right and use it for something else, the court has told you you run a risk right there. That statement from the court, that risk of requalification, seems something like a warning or an observation. You're put on notice when you come in, that can happen to you. And we need to understand what that risk of requalification could mean. It could mean that in finally quantifying a volumetric amount, you no longer have the freedom to exercise that full diversion amount to greater or lesser extents year to year. There's going to be a cap put on it. That's the risk we run. So in the end, on this question of guidance from the court, I think we can look at it in one sense that the court has advised that you cannot expand or enlarge the use over that of a representative study period. And that study period then could be that period of time when you would be letting the water right for its true use. And what that does is helps us with that question a little bit of whether those years at the end of the water rights history when it was not being diverted, intentionally not being diverted for its beneficial use, do they need to be included to represent the historic use of that water right? So that's one consideration. That was my first point, is what the court's guidance is. The second point is how Senate Bill 183 contributes to this decision making. And again, looking at the faces, I think everybody was pretty much apprised of what was going on with Senate Bill 183, but just to make a couple points, the first thing it did for us was tell us that you cannot use undecreed or non-decreed use to support that period or that record of beneficial use. You can't buttress or use with a diversion that wasn't for decreed use. So we have that. And we also have from Senate Bill 183 that you need to include wet, dry, and average use. And that's, I think that makes logical sense. For it to be representative of an average of the average use, certainly that hydrologic, that climate perspective is important. So it should represent all of this. So that's the second thing Senate Bill 183 told us. Thirdly, and most relevant to our discussion today, Senate Bill 183 set out that a representative study period need not include all years in the history of the water right. So what does that mean? It's a statement, it's a direction. It's not a total allowance that says that way you can then select any years you want, because it need not include all years. It's just saying as a standard, it does not necessarily need to include all years. So what, again, to me, that means there may be years that can be excluded, but you cannot selectively pick the best years to use that in your evaluation of historically considered use. So that's what Senate Bill 183 wrote for us. The third item I wanted to touch on was the concept of junior water rights being entitled to street positions at time of appropriation. And I think that's maybe one of the greatest or fuzziest areas, because it seems to be an ideal, and we need to understand what that concept is. Does it mean that administrative regime on the river at the time of the appropriation needs to be maintained? That is, for this change of water right, the return flows need to be maintained, the use can't be enlarged? Or does it mean that we all really need to try to replicate exactly what was happening on the river on that date? And I think the last one that I mentioned there is obviously not the case, because there are situations, obviously, where conditional water rights will eventually come online that were not online when that junior made the appropriation. We also have absolute water rights that may have not been diverting at that time for a few years for some reason, and then may come online again. So we really can't manage that ideal of truly protecting those strict conditions. The other thing, from a mathematical standpoint, one of the concerns I've had with that premise of including years of zeros from the end of the history to protect the juniors is that it really just has an incremental effect on that changed water right. And this is a good one to put numbers to, if I could, real quick. If we're talking about changing a water right with a 10 acre foot consumptive use amount, and we determine that there is 10 years at the end of the 100-year period where there was no diversions, water had been taken out of production. If we decide we need to include those zeros, we really reduce the water right by an amount of 10%. We go from 10 acre feet down to 9 acre feet. For that junior that developed during that 10-year period, what they see is the 10 acre feet they relied on, came to rely on for a few years. 9 acre feet of it still gets changed, and it's not available to them. So I just want to be careful of saying that we can truly protect the juniors by taking that approach. So while that is an ideal, I just want to make sure that we don't misinterpret the Supreme Court's direction on protecting the juniors and
trying to protect the water rights at the time of the stream conditions at the time of appropriation. The last one I want to talk about is what is the state engineer's role? And this gets back to Dick's discussion again. And what that role is really seen. I think we can still say, after having had this discussion and Dick's discussion, that we need to consider being a technical expert in some context. And in being that technical expert and looking at technical analyses on historical consumptive use, we are going to have to address the representative study period question. There's no way out of it. It's part of the analysis. And I really, I want to, again, be careful of the notion, going back to Dick's discussion, that because the state engineer has no water rights, he doesn't belong in water court cases at all, because I think we explored some of the value of, at some level or another, as a proposer, as an advisor, in certain cases, but not others. There is a value in the state engineer being involved. So I want to stick with that. And certainly the law directs the division engineer's participation right now at a technical level with the summary consultation. So that's part of the reason that we have this significant technical expertise. I'm looking at some of our DWR staff, and hopefully you do recognize the technical expertise that I do that allows us to play a role in this. But having said all that, we have to look at the fact that representative study period question is something that goes into a technical analysis, but it's not part of the technical analysis. And it may be more of a policy-oriented question that you all and the courts need to work their way through, but the state engineer is not any smarter at making that policy decision than all of you in the courts. So that's an important consideration, because we want to play the role that Dick described, but we want to play responsibly and be an important part of it, and not try to influence something that we are not better at than someone else. So just to summarize this, and then I want to open it up to questions. Hopefully we have a few minutes for questions and for Paula to follow. But we want to continue to be engaged in this. We need to bring our technical expertise to make sure the provisions of the law are met. And that includes things like including wet years, dry years, and average years in an analysis, and making sure that there is not some selective approach to taking over the best years to enlarge that average historical consumptive use. And then that really comes down, again, to my discussion about this is for cases where we have period of record where at one point diversions ceased intentionally because the water was being moved to something else, or was certainly not being used on land. And one approach to that, just at the start, potentially every year from the date of appropriation to the date of application, is potentially part of that representative study period. And we also need to make sure that it's a continuous period, that years intermittently were not taken out. Satisfying that, we might want to consider that, or we need to consider that wet, dry, and average years are part of the representative study period. That's required by law. And having done that, if we have years that are not being included as part of the representative study period, I see two scenarios. One, there's intermittent years throughout the history of use. And if we have intermittent years excluded, I think there are probably three basic reasons why that should be allowed. And one is if there are administrative approvals like substitute water supply plans or irreparable water supply agreements, some reason that through an administrative approval the water right was being used for something else. Or in divisions 4, 5, and 6, specifically each Senate Bill 19 told us if the water right is enrolled in some formal conservation program, then by law, that does not be, those years do not be included in a representative study period. And then, of course, if records are just simply not available for some reason or another, then they don't need to be included. But that was those intermittent years. And for that period of years at the end of the water rights history, where it was intentionally taken out of production, maybe we can look at that and say, yep, that's true, what happened. If there's no intent to put it to beneficial use, that does not need to be a consideration or factored in, again, numerically as zeros into that record of historical consumptive use. Now, one important point for me to finish all this up, we haven't talked about abandonment, and that's very important because we also need to look at that period of years at the end of the record where the water right is not being used. Was there an intent for abandonment? Was somebody just not any longer interested in that water right? Or was it leased to someone and somebody was figuring it into their plans? So abandonment is always a question that can be raised in the context of this discussion. So I raced through that, and I want to see if Paul has any follow-up on this.
Thanks, Kevin. I just wanted to first just make the comment that I hope you guys appreciate that Dick and his senior leadership are really taking a hard look at the concerns that have been raised by the water community in recent years. And there's a lot of internal soul searching going on, a lot of debating within the agency, and I think it reflects well on the agency and their continued efforts to be open and to try to elicit feedback as much as they can. But having said that, there's just a couple things I wanted to follow up with on Kevin's presentation. The first is that notion that in those intermittent years where there was no use, there's a record that there was no use. What justifications exist for that no use? I think one of the points Kevin was making was that the engineers have no great expertise in what constitutes an excuse or, thank you, or justification for non-use. I mean, dad getting sick, the son going off to war, a quiet title action.
This is rain things. Look at all these great contractors for years. Well, they Greenville Partners.
So there still needs to be some analysis of that non-use, those non-use years, and whether, as the Supreme Court said in Sedalia, the court should consider long periods of non-use and whether that non-use is justified or not. And I think that standard still applies even though Senate Bill 183 was enacted. The other thing that I think is important from perhaps an engineering standpoint is what Senate Bill 183 said about undecreed use and how that figures into your analysis in certain years. Certainly, if you had a year that was all undecreed use, my understanding is that would be entered as a zero for the decreed use. But if you had a year that had diversions, and some of those diversions were going for undecreed use, doesn't necessarily mean you just leave that year out of the analysis, but you leave the diversions for undecreed use or whatever went to the undecreed use out for that year. And I'll have Kevin and Dick and any of the other engineers correct me on that. But I think that's one fine point about Senate Bill 183 is that it didn't say exclude years of undecreed use. It said exclude undecreed use. And we view that as taking the diversions that went to that undecreed use out of the analysis in any year in which it occurred. But the diversions that went to decreed use would still be included in that analysis. And so I think what Kevin's also suggesting by his presentation, and maybe I'll put a finer point on it, is that the engineers feel that if you come, for whatever reason, it took 10 years from you acquiring a water right to filing your applications, maybe you were you had a bunch of water rights you wanted to bring in at the same time, and it took you a while to get all your analysis done, all your agreements done, and to bring a number of water rights and do one big change case and one big log plan case. If you come in and you have that 10 or 15 years or whatever the period, 8 years, at the end of the water rights history, that, you know, if you give a justification and explain to the engineers, here's why it wasn't used for the last 10 or 15 years. I think they're going to, if it's a reasonable explanation, they're going to say, fine, leave it out. We won't include it in the representative study period. And you know, there are some divisions that they won't even raise the issue unless you got beyond 10 years, where that presumption of abandonment might be rising. And so if there's only 5 or 6 years, they say, yeah, just leave it out. But I think they want to be a little more consistent across the divisions and how they approach those years of non-use at the other water rights life. And I guess the last thing I wanted to mention was on abandonment. I think the engineer's position, and again, they'll correct me if I misspeak, is that if they do see that period of more than 10 years in a change case, I don't think they're going to raise abandonment unless they see some evidence, some affirmative evidence, that there was an intent to abandon. Otherwise, they'll just probably continue to deal with those long periods of non-use through the decennial abandonment process. And so I see Kevin shaking his head, nodding a little bit. So I hope you understand what I think the point was there. So with that, I'll stop talking. We'll see if there's any questions anybody has.